Afternoon, everyone. This is Kristen O'Neill with the Committee on Open Government. Thank you for joining me today. This afternoon, we'll be doing an overview of the New York State Open Meetings Law. To start out, I'll let everybody know that this program is being recorded and will be available on our website within the next week or so. I did enter into the chat a copy of both our website and the specific link to the training material. So if you go to opengovernment.ny.gov, scroll down the page, you're going to see a section, I would like to view training materials and recordings. And that's where you'll find both a PDF copy of my FOIL and Open Meetings Law presentations, as well as recordings of past WebEx programs. I will repeat that later on because I'm quite sure that not everybody has joined us already. So I'll repeat that towards the end of the program to let people know that the information is available, because invariably somebody will email me and ask me to send them the materials. But just so you know, the materials are already available on our website. So as you see on the screen, my contact information, my name, my title. This is the telephone number for our office. We have a couple of attorneys in our office, so if you have questions regarding the open government statutes, you're welcome just to call and ask to speak with an attorney. It doesn't have to be me. There's our website, and there's our office email account, which is another way to contact us. Email us at coog@dos.ny.gov with your questions, and the first attorney in the office that is able to will get back to you. So the Open Meetings Law is codified in Public Officers Law Article 7. We always have an up-to-date copy of the Open Meetings Law on our website. Whenever we become aware of any amendments, updates, we make sure our website gets updated. So our website gets updated. So anytime you go to our website, you should almost always be able to see a most up-to-date version of the statutes. So giving a little legislative intent, the Open Meetings Law was passed in 1976, and the declared legislative intent stated that it is essential that public business be performed in an open and public manner, and that citizens be fully aware of and able to observe the performance of public officials. Citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. The Open Meetings Law governs conduct of meetings of public bodies, and that term is defined in the statute. I'm going to try to break it down for you because there's been some, in the past year and a half, there have been some amendments to the Open Meetings Law that were intended to codify both advisory opinions offered by the Committee on Open Government as well as judicial precedent. So the basics of what is a public body is it's an entity that requires a quorum in order to function, in order to conduct its public business, consists of 2 or more members performing a governmental function, either for the state, for an agency or department of the state, or for a public corporation as defined in New York State General Construction Law. So this includes public bodies are, for example, the state legislature, county legislators or county boards of supervisors, city councils, town boards, village boards of trustees, school boards, public library boards of trustees. Then you have other and thousands of units of local government across the state of New York, many of which have some type of governing body. You have water districts and sewer districts and things of that nature. And anytime they have a governing body, it's going to be a public body that's subject to the Open Meetings Law. So in addition to those full public bodies like the state legislature or public bodies that are either housed by a state agency or a local government. In addition to that full public body, any committee or subcommittee that is made up entirely or primarily of the full public body is also a public body subject to the Open Meetings Law. So let's say, for example, you have a 17-member county legislature, and you've designated 5 of those county legislators to serve on a finance committee. That 5-member finance committee then becomes its own public body. So now you've got the county legislature, where that is one public body, and you've got a finance committee that is a completely separate public body. And every time that public body meets, it must meet in compliance with the open meetings law. So that's, as I go through the definition, breaking it down. The next step is any entity created or appointed to perform a necessary function in the decision-making process and for which a quorum is required and which consists of 2 or more members. Then the statute goes on to clarify that a necessary function in the decision-making process shall not include the provision of recommendations or guidance which is purely advisory and which does not require further action by the state or the local government that houses the body. So that's sort of a lot to process. Try to break it down a little bit. First is to have 2 or more people been given the authority to act collectively. Is a quorum necessary to conduct public business? And the answer to this second question is sometimes. For example, there are many statutes that create public bodies that don't specifically state that a quorum is necessary in order to conduct public business. So sometimes the definitions become a little bit circular, but there's a provision of general construction law that we'll talk about a little bit later that basically says anytime you have a group of individuals that have been given the authority to act collectively, then they must have a quorum in order to conduct public business. So as I said, it's kind of a little bit of a circular logic, but so have 2 or more people been given the authority to act collectively? Is a quorum necessary in order to conduct public business? Is it a committee made up solely or primarily of members of the larger public body? If the answer to that is yes, then it's a public body. If it's not made up solely or primarily of members of the larger public body, then you need to ask whether it serves a state statutory function. Is there something in New York state law that designates a specific function to this entity? So for example, the Committee on Open Government itself, we're not a governing body, but pursuant to New York state statute, we are required to perform certain required functions. There's this New York state statute, specifically both the Freedom of Information law, the Open Meetings law, and the Personal Privacy Protection law assign certain functions to the Committee on Open Government, and it's more than merely providing advice. So the Committee on Open Government is a public body subject to the Open Meetings law. And the alternative, if you have an entity that is not made up solely or primarily of members of the larger public body, or an entity that is purely advisory in nature, has no statutory duties or final decision-making authority, the likelihood is that a court would find that such an advisory body is not a public body that is required to comply with the Open Meetings law. Oftentimes, this is not an easy question, and so it ends up being very factual sometimes. I mean, certain things have been well established by law or judicial precedents at this point, but anytime a new entity is created by statute to serve some sort of function in government, there's often questions about whether these entities are subject to the Open Meetings law, and it becomes a very factually specific question. So we have to evaluate the responsibilities designated to these entities to determine whether they're required to comply with the Open Meetings law. So I've talked quite a bit about quorum. New York State General Construction Law, Section 41 defines the term quorum. It says whenever 3 or more public officers are given any power or authority, or 3 or more persons are charged with any public duty to be performed or exercised by them jointly or as a board or similar body, a majority of the whole number of those persons or officers gathered together in the presence of each other or through the use of video conferencing shall constitute a quorum. And not less than a majority of the whole number may perform and exercise such power, authority, or duty. So in order for a public body to act as a public body, you have to have a majority of the total membership present. And in order to determine what the whole number, what the full body, what the number is that you are determining what is a majority of, you have to look at the total number that should be serving on the body if there were no vacancies and were none of the persons or officers disqualified from acting. So here again, I'll use my own experience with the Committee on Open Government. By statute, the Committee on Open Government is supposed to have 11 members. So a quorum of the Committee on Open Government is always going to be 6. Even though right now we're short 2 members, and even if everybody that's supposed to shows up to our meeting, we still are only going to have 9 people showing up to our meetings. All the appointees, if all of the appointees show up, we're still going to only have 9 members present at our meetings right now because we're 2 members short. That doesn't matter. In order to determine what is a quorum, we have to look at how many people should be serving on the committee, and that's 11. So even though 9 people are only currently on, you're always going to look at the number of 11 to determine what is a quorum. And for us, a quorum is always going to be 6. Let's spend a little time. I know this has been in effect for over a year now, Chapter 56, but to a large extent, people are still struggling with trying to figure out how to deal with it. Part of that has to do with the fact that Chapter 56, which relates to the expanded use of video conferencing under extraordinary circumstances, it passed in April of 2022. But to a large extent, many entities didn't give it a whole lot of thought because there was another statute that was in effect that allowed those public bodies to have completely remote meetings while the COVID state of emergency was in effect. So up until September of 2022, the state of emergency issued by the governor's office relating to COVID allowed public bodies to have essentially fully remote meetings. So between the time that this law was passed in April of 2022 and the time that the declared disaster emergency expired in September 2022, I think there was quite a few public bodies that didn't give Chapter 56 relating to video conferencing a whole lot of thought. So then last fall, when the state of emergency expired, public bodies started to really have to pay attention to these extended to see whether they wanted to authorize the use of extraordinary circumstances video conferencing. So as I said, it was passed in April of 2022, and it amended the open meetings law to expand the use of video conferencing by public bodies to conduct open meetings under extraordinary circumstances, regardless of a declaration of emergency. This provision currently is set to be in effect until July 1st, 2024, unless extended by the legislature. So this new provision is not meant to change or curtail what has always been permitted or required of public bodies in relation to compliance with the open meetings law. Public bodies may continue to operate now as they did before the onset of the pandemic in early 2020, when the in-person aspect of the open meetings law were first suspended. In other words, we believe that if a public body was permitted to do it before the pandemic, this law does not change that. As not noted above, the law is intended to expand in extraordinary circumstances only the ability of public bodies to meet using remote access technology. To break it down a little bit, there are 2 ways to use video conferencing technology to conduct an open meeting. The first is what I would refer to as the pre-COVID way, the way that has been authorized for many years now, where you're connecting multiple physical locations that are all open to in-person public attendance through video conferencing. Here, Committee on Open Government has a meeting. We're housed within the Department of State. So when we have a meeting, we allow our members to choose which location between Albany, Buffalo, and New York City is closest and most convenient for them. We put out a notice to the public and say, these are the 3 physical locations where we plan to have our meeting. Some of our members may go to Buffalo, some may go to Albany, some may go to New York City. We connect all of those locations through the use of video conferencing, and we let the public know that they are free to attend any of those locations. So all of those places are open to the public, and the member can choose which one to attend, which location from which they want to attend. So that's the manner of using video conferencing that has been in effect for several years now. The second mechanism is the new way, the Chapter 56 way, which allows a member of a public body to participate from a private location, a location that is not open to the public, through video conferencing, but only under extraordinary circumstances. The public body is using the first type of video conferencing, where you're connecting multiple physical locations that are open to the public. The new Section 103A of the Open Meetings Law does not apply. Public body may, in its discretion, use video conferencing to conduct its meetings pursuant to this new provision, provided that a minimum number of members are present to fulfill the public body's quorum requirements in the same physical location or locations where the public can attend, and the following criteria are met. So in order to allow any of a public body's members to attend from a private location, you must first have a quorum of your public body present at an open location. There was a recent amendment to the Open Meetings Law that states that if one of the members who wishes to attend via extraordinary circumstances video conferencing due to a disability, and that disability renders the member unable to participate in person at any meeting location where the public can attend, those individuals are permitted to be considered present and count towards a quorum for that meeting. So normally, if a member is attending from a private closed location via video conferencing, they do not count towards a quorum. But if the reason they are attending from that private location is because of a disability that renders them unable to participate in person, if that's the case, then they are allowed to be counted towards a quorum. And the term disability is defined in New York State executive law. So summarize, members who are participating from a physical location that has been properly noticed and is open to the public do count towards a quorum and may fully participate and vote. Members who are video conferencing from a remote location that is not open to in-person public attendance do not count it towards a quorum unless they meet the disability criteria. They may, however, fully participate and vote if a quorum has otherwise been met. In order to allow members of your public body to attend via extraordinary circumstances video conferencing, a public body must first, governing bodies, we'll break it down even further, governing boards of counties, cities, towns, or villages must first adopt a local law. The state, Senate, and Assembly had to adopt a joint resolution, and all other types of public bodies had to adopt a resolution. All public bodies must have had a public hearing, or if they haven't done it yet going forward, must first have a public hearing prior to passing the local law or resolution. A public body can pass a resolution or local law for itself and its committees or subcommittees, or it may specify that each committee or subcommittee may make its own determination. Community boards in New York City shall all make their own determinations. Sorry about that, I just had to do something quick. The public body must establish written procedures governing member on public attendance consistent with this section, and the written procedure shall be conspicuously posted on the public website of the public body. Members of the public body must be physically present at the meeting unless the member is unable to be physically present due to extraordinary circumstances. The definition of extraordinary circumstances has to be set forth in the public body's resolution and written procedures, and should include, at a minimum, the examples provided by the Open Meetings Law, which includes disability, illness, caregiving responsibility, or any other significant or unexpected factor or event which precludes the member's physical attendance at the meeting. Except in the case of executive sessions, the public body shall ensure that members of the body can be heard, seen, and identified while the meeting's being conducted, including but not limited to any motions, proposals, resolutions, or any other matter formally voted upon. So if you have somebody signing on through WebEx or Zoom, something like that, they need to have their cameras on, which was not required during COVID. During COVID, people could just really log on just with their voices. Now there's an obligation to be heard, seen, and identified. So people need to have their cameras on. And when they're logging on, they should be entering their full names on the screen. So sometimes when people log onto these meetings, maybe they use an email address or a phone number. But for this purpose, public members of public bodies have to enter their full names. Minutes of these types of meetings have to include which, if any, members participated remotely and must be available to the public pursuant to the Section 106 of the Open Meetings Law, which we'll talk about in more depth as we move forward. If this type of video conferencing is used, the public notice for the meeting shall inform the public that video conferencing will be used, where the public can view and or participate in the meetings, where required documents and records will be posted, and identify the physical location or locations for the meeting where the public can attend. The public body shall provide that each meeting conducted using this type of video conferencing must be recorded, and the recordings must be posted or linked on the public website of the public body within 5 business days following the meeting, and shall remain so available for a minimum of 5 years thereafter, and the recording shall be transcribed upon request. During COVID, the language of the statutes and the executive orders said later transcribed. The new language says transcribed upon request. So if no one asks for it, there's no obligation to prepare it. If you're using entities, if you're using platforms such as WebEx or Zoom, I would encourage you to take advantage of any AI transcript service that those platforms offer. It's sufficient to comply with law. That's perfectly fine. If this type of video conferencing is used, the public body shall provide the opportunity for members of the public to view the meeting via video and to participate in proceedings via video conference in real time where public comment or participation is otherwise authorized. Must ensure that video conferencing authorizes the same public participation or testimony as in-person participation or testimony. So during COVID, we would often get questions about whether a public body needed to allow individuals that were attending remotely to participate in the public comment period that was available to people who showed up in person. And, you know, it was sort of an ongoing conversation because neither the executive orders or the statutes that were in place at the time addressed it. Here, the law is very specific that if you allow public comment for people that show up in person, you also have to allow public comment for people that attend remotely, but only if you're letting your members attend using extraordinary circumstances video conferencing. So whatever rules, if you're using extraordinary circumstances video conferencing, whatever rules apply to public comment for people that show up in person, you need to apply those same rules to people that attend remotely. The law requires that a local public body that wants to utilize extraordinary circumstances video conferencing to conduct its meetings must maintain an official website. And this is because there are certain posting requirements that are imposed. So the local public body, if they don't have its own website, an official website, they wouldn't be able to comply with statutes. So the law specifically states, well, if you want to do this, you have to have an official website. There's a provision of the statute that says if there is a state disaster emergency declared by the governor or a local state of emergency proclaimed by the chief executive of a county, city, village, or town, if the public body determines that the circumstances necessitating the emergency declaration would affect or impair the ability of the public body to hold an in-person meeting, the in-person meeting requirement can be suspended. So essentially, if there is such a disaster emergency, a public body could revert to having meetings the way that they took place during the COVID public health emergency. The law requires the Committee on Open Government to issue a report to the governor and the legislature concerning the application and implementation of this amendment, and make any further recommendations governing the use of video conferencing by public bodies to conduct meetings pursuant to this section. This summer, we've been lucky to be able to obtain a college intern. Her name is Elizabeth Baird. Some of you who are on this afternoon may have already spoken with her and had an opportunity to interact with her. We've been reaching out to individuals that have signed up for my programs, for my training programs. I've tried to reach out to different government organizations to get as many people as possible who are interested in participating in our survey. Elizabeth's just going to be asking a really quick series of questions regarding the experiences of both public bodies, but also just the public generally and media, to see if what people think of these new provisions. And if we have recommendations going forward for the legislature about what changes we might want to make, what we might want to see going forward in terms of remote access for meetings. If we haven't reached out to you yet, if this is the first time you're hearing about this, but you would like to participate in this survey, you're welcome to email us. Elizabeth can either call you, or we can send you a written copy of the survey, whatever's easiest for you, and we can go through the questions that are on the survey and get some feedback from you. We really would like to hear from as many people as possible to get the full experience of what people are thinking about these provisions, so we can pass that information along to the governor and the legislature. So I'll just throw that out there again. If you would like to participate, just send an email to coog@dos.ny.gov, and Elizabeth will follow up with you. One other thing is that if you're using this type of video conferencing, the technology must permit access by members of the public with disabilities consistent with the 1990 Americans with Disabilities Act. Our office cannot provide legal advice regarding the ADA, so I would recommend that if you have questions regarding ADA compliance, reach out to your own legal counsel. All right, so that's sort of my wrap up about the new extraordinary circumstances video conferencing provisions. I'll take this opportunity again because I know not everybody was logged on right at the dot at 2 o'clock. This program is being recorded, and I will put, as soon as it's done and downloaded, I will put in a request to our IT staff to have it uploaded to our website. I'm not sure, hopefully, give me just a second here. I'm going to open the chat feature, and I'm going to re-enter into the chat feature a link to where both my materials are, and just a second. I'm going to put in chat right now. This is a link to the Committee on Open Government's website, but specifically the section of the website that links to both my training materials, PDF copies of this PowerPoint, and my Freedom of Information Law PowerPoint, as well as a link to our YouTube page that has recordings of previous programs, and we'll ultimately have a recording of this program as well. Notice of all meetings of the Open Meetings Law must include the date, time, and location, and if appropriate, instructions for virtual attendance must be given prior to every meeting to the media. Does not mean that the public body needs to purchase a legal notice. It just means that the media must be notified. The notice must be placed in a designated physical location. If an agency or public body has an active website, the notice must be posted to that website. The notice must be given at least 72 hours prior to a meeting that has been scheduled at least 1 week in advance. For meetings held on short notice, notice must be given to the extent practicable at a reasonable time prior to the meeting. The Open Meetings Law itself does not specify when a public body is allowed to have meetings with less than 72 hours notice, but the courts have weighed in, and the courts have suggested that the propriety of scheduling a meeting less than a week in advance and providing less than 72 hours notice is dependent upon actual need to do so. In terms of notice, if extraordinary circumstances video conferencing is used to conduct a meeting, the public notice for the meeting shall inform the public that video conferencing will be used, where the public can view and or participate in the meeting, where required documents and records will be posted, and identify the physical location for the meeting where the public can attend. Records scheduled to be discussed during the meeting. October 19th of 2021, Governor Hochul signed into law Chapter 481 of the laws of 2021, which amended Section 103E of the Open Meetings Law to require that records to be discussed at an open meeting be made available to the extent practicable upon request and posted online at least 24 hours before the meeting if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. The obligation to make records available to the public upon request prior to or at the meeting and to post the records on the agency or public body website prior to the meeting has been in effect since February 2012. This amendment simply places a 24-hour minimum time frame for making those records available. There was many public bodies when this amendment took place. We became aware at that time that there were many public bodies that didn't realize that they were supposed to be making the records that they planned to discuss during the meeting available prior to or at the meeting. So just as a reminder, this has been a statutory requirement since February of 2012. The October 2021 amendment simply placed a 24-hour minimum time frame for making those records available. What does this include? Includes any proposed resolutions, laws, rules, regulations, policies, or any amendments thereto. It includes records or portions of records that are public under FOIL and are scheduled to be discussed during the open meeting. Law says that the agency may, but is not required to spend additional money to implement this section, and it does not apply to records that are discussed in executive session. Minutes. Minutes of an open meeting must include the motion, a record or summary of all motions, proposals, resolutions, or any other matter formally voted upon and the vote thereon. If extraordinary circumstances video conferencing is used, it must include which, if any, members participated remotely. For executive session, minutes of an executive session are only necessary if action is taken in an executive session. Must be available within 2 weeks for an open session, 1 week for an executive session, and it does not matter whether the minutes are unapproved or in draft form. They still must be made available. November of 2021, Governor Hochul signed into law Chapter 587 of the laws of 21, which amended the open meetings law to require agencies that maintain a website and use a high-speed internet connection to post meeting minutes on its website within 2 weeks of the date of the meeting, or within 1 week of an executive session. The law further states that for purposes of this subdivision, so heavy emphasis on for purposes of this subdivision, unabridged video recordings or audio recordings or unabridged written transcripts may be deemed to be meeting minutes. This does not relieve a public body of the obligation to prepare written meeting minutes. The public body must still prepare meeting minutes consistent with the requirements of Section 106. This exception, so to speak, simply allows a public body to post unedited video or audio recordings or unedited written transcripts on their website instead of posting the meeting minutes. That's all that provision is meant to relieve a public body of. It is not intended to relieve the public body of its obligation to prepare minutes generally. Recording. Any meeting of a public body that is open to the public shall be open to being photographed, broadcast, webcast, or otherwise recorded and are transmitted by audio or video means. An individual who wishes to record or photograph does not need to provide prior notification, does not need the board's permission. they have a right to record, photograph, broadcast. An agency is not obligated to record itself unless one of its members is participating remotely as authorized under Section 103A. An agency may establish reasonable rules to limit disruption or interference, and we have model rules relating to that, and they're available on the Committee on Open Government's website. Executive session. An executive session is defined in Section 102, Subpart 3 of the law as a portion of an open meeting that is not open to the public. An executive session is not a standalone meeting that is either prior to or separate from an open meeting. In order to enter into executive session, a motion must be made and voted upon during an open meeting. So an open meeting must be noticed to the public, and then once the start time as noticed has passed and the meeting has started, at that point, then the public body may make a motion to enter into executive session. The motion to enter into executive session must contain sufficient detail to reflect to fellow board members and to the public that the public body is entering into executive session for a proper purpose. The motion does not need to be so detailed that it defeats the purpose of the executive session, but it does need to be detailed enough to reflect that the body is going in for a proper purpose. So up on the screen, you'll see these are the 8 reasons that a public body is permitted to enter into executive session. If you don't see it on this list, it means it's not an appropriate conversation to be having in executive session. Reminding everybody again, this information is available on our website. This is directly from the statute, but in addition, these slides are available on our website under the training material and recording section of our website. I'm going to go over some of the more common grounds for entering into executive session. Maybe flip back and forth a little bit, but the first one I always talk about is over and over and over again, no matter how many times we ask public bodies not to use this term, we see it anyway. Often we see, whether either in the agenda or meeting minutes or because we're listening to the meetings, public bodies will make a motion to enter into executive session to discuss personnel matters. The word personnel does not appear anywhere in the open meetings law. It is not an appropriate and sufficient motion to enter into executive session to state you're entering executive session to discuss personnel matters. It is not sufficient to comply with the law. The courts have weighed in on this. What the law does allow a public body to discuss in executive session is the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. So when a public body makes a motion to enter into executive session, the courts want to see that it's specific. But they do not want to see public bodies merely mirroring the language of the statute. So you have to think about it a little bit. What do we plan to talk about? Use everyday language to explain what we're going to talk about without defeating the purpose of the executive session. So an example might be, perhaps you've received applications to fill a particular position and they need to be reviewed. So you might say that I move to enter into executive session to review and discuss the employment histories of applicants for position A. Perhaps if you have, there's been allegations of misconduct against one of your employees, you may make a motion to enter into executive session to discuss the employment history and matters leading to potential discipline against a particular employee. And no, you don't need to identify the name of the employee. So again, you're going to pull the specific language that's appropriate for your situation. So I didn't mean to go forward, to go backwards. So that's the one that I have the specific slide on. There's some others that come up with some regularity. Section 105(1)D, discussions regarding proposed, pending, or current litigation. So if you've been served with a notice of claim as a public body or as an agency, if you have actively been sued, a petition and notice of claim, or excuse me, a summons and complaint has been filed in your local Supreme Court against your agency. Or flip side, you as a government agency have initiated a lawsuit against another entity. Those are the types of conversations that you are permitted to have in executive session for the purpose of discussing litigation strategy. What are you not allowed to discuss in executive session? You'll notice that the word potential or possible does not appear in this language. Some public bodies I've noticed have attempted to squeeze in a little bit more than what's permissible by saying they want to discuss potential litigation against the agency. That is not permitted under the statute. Everything a public body does has the potential to lead to litigation. So you cannot discuss, a reason for entering into executive session is not potential litigation. That is not sufficient to comply with law. Even if someone says, if you guys do this, I'm going to sue you, that's not sufficient. Potential litigation is not enough to enter into executive session. It has to be proposed, pending, or current litigation. Collective bargaining negotiations under the Taylor Law may occur in executive session. Sometimes, very frequently, we see public bodies saying that they're going to enter into executive session for contract negotiations. That language is not sufficient. If it's actually collective bargaining negotiations, fine, that's okay. You got to say that. In fact, you should probably specify which union you're having collective bargaining negotiations with. Contract negotiations is not a topic of conversation that can occur in executive session. It does not appear anywhere in the statute. Another common ground for entering into executive session is the proposed acquisition, sale, or lease of real property or securities, but only when publicity would substantially affect the value thereof. So if a local government, a government agency is considering either purchasing or selling a piece of property, and they want to have a conversation in executive session, either how much maybe they're willing to offer for a piece of property, how much they're willing to accept for a piece of property, what are the parameters, how high they're willing to go, how low they're willing to go, things of that nature. Those are conversations that would appropriately be held in executive session, because if everyone was aware of, for example, how much a particular government agency was thinking of offering for a piece of property, it could put that government agency in a weakened bargaining position. So that's the reason why that is permitted to be held in executive session. So the whole concept of executive session is being able to have conversations behind closed doors, where if those conversations were held publicly, it would cause harm. It would cause harm to the public. It would cause harm to a public employee. It would cause harm to the government agency itself. Embarrassment is not the same as harm. This would be actual harm. There are two mechanisms for meeting behind closed doors under the open meetings law. The first is executive session, and that's the more commonly known. The second is section 108 of the law, which is exemptions. If an exemption applies, the open meetings law does not. It's as if the open meetings law does not exist. The three exemptions are: 1, judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and zoning boards of appeals. 2, deliberations of political committees, conferences, and caucuses. And 3, any matter made confidential by federal or state law. Example of the first one might be, for example, boards of assessment reviews. Boards of assessment reviews sometimes have quasi-judicial proceedings. In the portions of those board meetings that are actually quasi-judicial proceedings do not need to comply with the open meetings law. deliberations of political committees, conferences, and caucuses. For example, if you have a town board that is a split between Democrats and Republicans, the Democrats can meet all together without triggering the open meetings law. The Republicans can all meet together without triggering the open meetings law, even if one of those groups constitutes a quorum of the full public body. Say the Democrats are 3 and the Republicans are 2. Those 3 Democrats can meet and talk about whatever they want, whenever they want, without having to notice it to the public. Clearly, they can't vote, they can't make decisions on behalf of the town when they have those conversations, but they are permitted to discuss whatever they want. The third one, I would say probably the most common example of that third bullet are conversations between a government's public body, such as a town board or a village board, city council, and their legal representation. So maybe you've got the town board meeting with the town attorney for the purpose of requesting legal advice from the town attorney, and the town attorney is playing an active role in providing that legal advice. That conversation would then be covered by the attorney-client privilege, which is a matter made confidential by New York State law, by New York State civil practice law and rules. So that conversation, as long as the attorney is playing an active role. Now, granted, the mere presence of the attorney is not sufficient to assert the attorney-client privilege. It has to be where the attorney is actively providing legal advice. If that's the case, that conversation, that meeting between the public body and the attorney is exempt from the open meetings law. Don't need to provide notice, don't need to prepare minutes. It can be a conversation that can occur completely outside the scope of the open meetings law. Non-compliance and enforcement. The Committee on Open Government does not have enforcement authority. Enforcement is through the initiation of a civil practice law and rules Article 78 proceeding in state Supreme Court. A prevailing party, the court has the authority to award costs and attorney's fees to a prevailing party. If the court finds a substantial violation of the open meetings law, actions taken either at a meeting where the violation occurred or as a result of meetings held in violation of the open meetings law, those actions can be invalidated by the court. There's a specific provision of the open meetings law that states that mere technical violations of the open meetings law are not going to be sufficient to trigger a court to invalidate the actions. Another penalty that can be imposed is that a public body can be required to take training from the Committee on Open Government, which hopefully is just always a positive in helping people understand rights and responsibilities. Again, anyone's welcome to contact our office by phone or by email with questions, whether you're a government employee, members of the public, media representatives. You can call our office and ask to speak with an attorney. You can email our office with a question, and the first attorney available will get back to you. coog@dos.ny.gov. Again, you're also that you can use if you would like to participate in that survey or provide feedback for that survey. You're welcome to email that address, and Elizabeth will be in touch with you. Elizabeth Barrett is her name. We'll follow up with you. So I'm going to include a link. I'm going to exit out of screen sharing. I'm going to go into our chat and take any questions that may have come up or come up in the next couple of minutes. Sorry, I'm just going to stop my sharing. And I want to go into my chat. There we go. I'm going to chat nice and big so I can see it because I'm getting old and can't see so good. There we go. So I'm going to enter this again just in case anyone missed it. A recording of this program will get posted to our website. In addition, the training materials for both this morning's FOIL program and this afternoon's Open Meetings Law program, a PDF copy of these materials are available on this link through this link. So now I'm going to go back to the beginning. Doesn't look like we have too many questions, which is great. Hopefully, everyone's got a good grasp of what we talked about, but feel free in the next couple of minutes if something comes up, you can type it in, but I'll go through the questions that exist there. Question is there suggested language to put out to public body members to ask if they feel they meet Section 103A2C? We are unaware currently if a member has a disability, as this has never been asked before. I think ultimately, if a public member of the public, if you've authorized the use of extraordinary circumstances video conferencing, and a member of your public body comes to you and says, I want to be able to participate via extraordinary circumstances video conferencing, they do need to tell you how they fit within the definition of extraordinary circumstances. They don't need to tell you what their disability is, and I don't think it would be appropriate to ask. But if they say, due to my disability or due to my illness, I do think it's appropriate for them to be, the onus being on them to identify how they meet your public body's definition of extraordinary circumstances. But I don't think you need to go so far as to ask them to identify their disability or their specific illness. But the onus, if they want to take advantage of this provision, the onus is going to be on them to say how they meet the criteria. Someone also asked, the same person asked whether sample resolutions can be shared regarding the disability policies and procedures. If you're talking about specifically about extraordinary circumstances, that we have available on our website. I'm going to pull it up right now. And so on our website, we have a Q&A regarding these provisions, the extraordinary circumstances, and we have a model resolution and a model policy. So I just sent that through the chat if anyone would like to cut and paste that. Let's see. Regarding persons with qualifying disabilities counting towards the quorum, of public body has already enacted a local law which expressly says that if a member participates through EC video, they don't count towards a quorum. Would they need to amend the local law to allow for the new 103 allowance for members with disabilities? It's a very good question. Thank you for asking it. To be honest, you're the first person that's asked me that. It may, actually, I think it would probably be a wise decision to amend the local law, but in the interim, because the open meetings law specifically requires that member with that disability who states that the disability is prohibiting them from attending the meeting, there's a state statute that says you have to count them towards a quorum. So I think even if you haven't passed if you don't amend the local law, you can still allow your members with a disability who state that the disability is impairing their ability to attend in person. If they affirmatively state that, you can let them count towards a quorum, even if you don't amend your local law. But I think it's a great question. I think I would encourage it to get codified in your local law. So great question. Thank you. Let's see. Someone said, how should one address board members who continue to discuss agenda items via email outside the open meetings law? I can say it's not prohibited. The open meetings law doesn't prohibit board members from discussing agenda items via email outside of the open meetings law. Certainly they can't vote on issues. I certainly have concerns where public bodies are engaging in substantial deliberations regarding agenda items, where they're essentially coming to decisions and hammering out all disagreement relating to any particular item before they get to the meeting. Those conversations should be being held in public. And the best I can recommend is just to keep reminding your members that it's important to act in a manner consistent with the open meetings law, that the intent of the open meetings law is to allow members of the public to witness not just the decision making, but the deliberations that go into decision making. That's what the intent of the law is. And by simply having all deliberation via email and no deliberation during an open meeting, they are exposing themselves to legal liability. Again, the law does not specifically prohibit public bodies from discussing agenda items via email. Again, they can't vote, obviously, but the intent of the law is that those conversations should be had in an open meeting. What constitutes public business for the purpose of open meetings law? It's very broad. There isn't a definition. And the person goes on to say, in terms of business being within the public body's scope, yes. What's the purpose of this public body? If they're discussing anything within the scope of their responsibilities, then that's public business. The person who's asking the question goes on, for instance, if the quorum of a standing committee on health gathers and discusses business outside of its specific jurisdiction. I guess my question is, the person goes, i.e. topics arguably public business in a more generalized sense, but not health related, would the discussion be subject to the open meetings law? I guess my question is, why are they doing it? Are they doing it just because they're a group of people that are interested in the topic? Okay, but what it comes down to is, are they in some way trying to evade the open meetings law? I don't think I have a simple answer for this question. I mean, if the purpose of a committee is to make, a standing committee on health is their only responsibility, their only designated authority is to make recommendations to the full public body relating to health issues, then any conversations they have outside of that scope of responsibility probably don't have much bearing. There's not much they can do by having those conversations. But if for some reason these conversations relate to any part of their responsibilities, I certainly would encourage those conversations to be held within the open meetings law. If our public body does not have extraordinary circumstances in place already, how should we proceed? If you haven't passed a local law, if you are a municipality and you haven't passed a local law yet, but would like to, that's what you need to do. A local law needs to be proposed, there needs to be a public hearing, and then there needs to be a vote on passage of the local law. So that's the extent of the questions that I have. If anyone thinks of questions later, you're welcome to email me. And again, always, if you just have questions going forward regarding freedom of information law, open meetings law, please feel free to email our office or call our office whenever you have questions. We're happy to help. And I hope everybody has a lovely day. Stay safe if you're in the eye of the storm, and have a good weekend. Thank you, everyone.